when you're in the courtroom and in trial, your personal insecurities or faults are magnified. I mean, there's an audience there. And if you don't have the awareness and I don't want to say control, but just the understanding of who you are and what it is, it gets to be ugly and goes south real fast, and that case is over. And so that was really my initiation to therapy is I don't like how I'm reacting in these situations, and I want to know why because I want to prevent it. And then all this work with Sorry and, I Trial by Human and Rick Friedman. Those things are, I think, are the most important for my personal development as a trial lawyer. My experience early on was I tried to do this one system exactly how they said it and wear everything that they wore and do what they did. And I got just not good results. And it was incredibly frustrating. I would try a case and come back and get all this, the people that weren't in the arena would tell me what they thought, which was nice, but it was kind of like after the fourth or fifth time, it was like, guys, maybe I just am not good at this, but then I started to hear about Nick Rowley and what they were doing. And you take bits and pieces. And what I really liked what he was saying was the freedom to try the stuff on. If you don't like it, don't do it. And then you do some Mitnick and you try some of that on. And you go with what you wear, what fits you, and utilize it. And then you have that authenticity. And I think it's, for me, luckily, it's produced some decent results. I hope they continue. But it's a solid, I think you don't have to pick one.
I mean, I think there's a danger of just kind of like reading every book and, say, I'm going to spend 20 minutes on this and 30 minutes on that. I mean, I think you need to go to some seminars, do some practice, get some coaching so you can learn the different methods. But then you got to find out what aspects of each one of them to create. It's almost like we each have to create our own. I mean, we don't have to each write a book and, try to create a following, but we need to find, for us to be authentic and powerful in the courtroom, what is it that we need? We have to kind of adjust our mindsets that, we go in there, we do everything we can, and it's great when we win. And we can do a lot of things to increase our odds of winning and increase our odds of getting a bigger verdict. But there's no guarantees, and, no one remembers your losses.
Around here, a lot of our treating doctors are by video deposition for trial, and they're edited. And we work really hard to get those down to 10, 11 minutes. Because, whoever sat there and listened to a doctor on video drone on for 20, 30, 40, 50 an hour. I mean, that is something's not working out right. It's either too complicated or the jurors are very bored. So brevity and being concise about really paring down what's important has helped us a lot. And it helped keep our focus because like any trial lawyer, we all get really into the cases, into the cases. And you think this is really, I need to point out this fact. I got to find a way to get this in. Well, nobody cares about that fact probably. It's like, is it something in the instruction they need to know? Or are you just trying to get some aggravating circumstances that don't really have to do with your damages? And part of that is us discerning that line, cutting away that stuff, and then going with what really the case is about and then keeping the focus on that while still learning the case. Why create a fight in front of the jury that wastes their time about something nobody even cares that my client didn't even really pay? That was the subrogation amount. And so I've never, in any of the cases I've tried, had past special damages in the case, even if they've been hundreds of thousands of dollars. I just don't, because if that's the case, I'm asking for $5 million or 7 or 10 or whatever. And what's $300,000? We don't have to do it in Missouri. We only have one line for damages. You don't have to parse out economic or non-economic. Oh, wow. Yeah. So it's any damage is what our instruction says. So we leave it out, and it does kind of confound the defense because all they do is harp on there's no medical bills in this case. That becomes their theme. And it's like, well, no shit. I told them that. Those are the first words out of my mouth. There's no surprise. And so we waive those and just focus on, you tell them from the outset, this is going to be a case about non-economic damages, pain and suffering. These are these are cases that are under the law can be brought. So we really were big on staying healthy and, making sure we were getting the sleep we needed, all those types of things to make sure we showed up in the right mindset.
That is so important. And it's so easy to go work till, midnight, 2, 3 in the morning during trial. And at least as I've gotten older, it doesn't work for me very well.
I used to do that too, but what happens to me is the ideas don't really improve, just the quantity of ideas go. And so now I'm writing a million things in my trial notebook that now it's just word vomit all over the page. And it's like, I'll even flip back a few pages and be like, hell, that was a really good idea from, I don't even know when I wrote that, but that was good.
Yeah.
And I forgot about it.
Yeah.
I think it's good to have all those ideas down because you're not sure how the evidence is going to come out and you can kind of pick and choose. But I do believe shutting it down at a certain time, and I'd rather get up earlier than stay up later. And doing it that way is probably where the good stuff came from. In jury selection, I thought, folks, here's your only job in this case is going to be deciding the damages, the dollar amount of the equal trade, dollar value, whatever you like to say, the number that is the fair, reasonable 100% of damages. And that's inside this box. That's your job is inside the box. Who pays it, what pays it, how it's paid, if it's paid, when it's paid, all that stuff is for the judge. All right. Are you going to trust the judge to do his job? No one's going to say no because he's sitting in a black row. We call them on, it's like, they'll raise their hand and say, yeah. And I say, okay, we need to trust you to do your job. So who's going to have trouble staying in the box? Who's going to want to know some of these other things to reach a decision? And especially when it comes to millions of dollars. Then now the hands start going up. And I need to know this information. Was there insurance involved? Well, if I answer it one way, it's unfair to one side. I answer it another, it's unfair to that side. That's regardless if they are or not. It has nothing to do with what your job is. I've been doing really hard on nasal breathing. I think it's very important. Not only control your anxiety or whatever it is, you control your sleep, your health, sinus issues, whatever anybody has. It's really helped me. And so throughout the trial, I made it a point that when an anxious point came up, like for almost all of us, it's when your client's testifying. There's nothing more anxiety inducing than them up there speaking. And, I just focused on, okay, this is an anxious feeling. Breathe it in, breathe it out, slow, controlled. This feeling will pass. This feeling will pass. It is just a feeling. It will pass. And trust that the work that you've done is there. And sure enough, she did. She knocked it out of the park. But it also kept me in my seat. That's, I think, the big key is we didn't object one time in the trial. So it kept me in my seat, which also shows the jurors my confidence in the case. And he said, all of us mentioned how you made eye contact with every single one of us and we felt included. And that is a good thing because you can have awkward eye contact, right? You can stare at people for too long. But it's like you think about a quarterback. He's got that internal clock where he's got to get rid of the ball before he gets sacked, whether there's pressure or not. He just knows it. I think the same is with eye contact. You kind of have that couple beats of, did you get me? Do I read you? Do I see you? Do I feel you? All right, boom, let's move to somebody else. And that I felt that was working in the trial, and it seemed to stick, and they noticed it. Nowadays, and I think you've probably heard a lot of guys say this and gals on your podcast say is, jurors are more aware of their relationships. I don't know if that's personally the truth, but maybe they're more comfortable talking about them, I guess. I don't know if they value them any more than they did before, but at least they talk about them. I haven't done enough, I guess, investigation into that, but they have no issue. And that's my experience the last 5 or 6 years, no issues with non-economic pain and suffering, change in life type of damages. And I think that they do, if the evidence is there, they think that has a ton of value.